Hi everyone, welcome to fifth day of webinar. Myself, Haima Joseph, first year LLB, Havanur College of Law. It's such a pleasure to see you all gathered here for today's exciting webinar on interpretation of the Constitution. We are in for a truly inspiring session, and the credit for that goes to our special guest, Professor Yogesh J. Now, let me tell you a little about him. Though I must say, one introduction can hardly do justice to his achievements. Dr. Yogesh is the principal of Best Law College, Mandya, and a powerhouse of knowledge with degrees like LLM, MPhil, MBA, PhD, and even a doctorate of literature. Yes, you heard that right. One person, many degrees. He is a brilliant scholar, a passionate teacher, and someone who makes even complex legal ideas sound simple and interesting. With specialization in corporate law, criminology, and forensic science, Dr. Yogesh has spent years shaping the minds of future lawyers and inspiring them to see law not just as a subject but as a living, breathing system of justice. Today, he will be helping us explore how our Constitution is interpreted and how its meaning evolves through judicial wisdom and how those interpretations keep our democracy alive and vibrant. So, get ready for a session that's going to be both informative and thought provoking. On behalf of everyone here, I extend a warm and cheerful welcome to you, Dr. Yogesh sir. We are so happy to have you with us today, and we cannot wait to learn from your experience and insight. Thank you so much, sir, and welcome once again.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you, one and all, and for the principal, Havanur Law College, Bangalore. Usually, I want to chant preamble whenever I want to start my class or webinar, whatever it may be. My dear ones, the topic I chosen for today's webinar is that interpretation of Constitution. We have heard that interpretation of statutes. So along with that means interpretation of Constitution vis-a-vis statutes. My dear ones, actually Article 147 Part 5, Chapter 4 deals with interpretation. What is interpretation? Interpretation is first we should read and understand the concept in the statute or constitution, whatever it may be, then we should apply it. What we call applied sciences in science field, like that. In judicial field, we call interpretation. And this interpretation is the main function of judiciary. So Article 147 leads to interpretation of Constitution, even though under Article 395, the Government of India Act 1935, as well as Indian Independence Act 1947 repealed, but for the use of interpretation, we should also consider all these two acts along with the remaining acts. So this is with regard to interpretation of Constitution and vis-a-vis statute. The first and foremost example I want to quote for this is that the famous case law, that is Joseph Shine case. Section 497 of Indian Penal Code in the year 2018 held that it was unconstitutional by interpreting the section 497. Actually, the section 497 runs as follows. A person who is having a sexual intercourse with a woman, knowing that she is wife of another man, without the consent of her husband, that sexual intercourse will not amount to rape, but amount to adultery. And for this purpose, the women cannot be treated as a abettor. This is what the section 497 was. After the Justice K.S. Putsami case, Supreme Court held that right to privacy is a fundamental right in the year 2017 by constitutional bench. If you want to interpret the constitution, the bench always should consisting of minimum 5 justices and above, like 5, 7, 9, 11, and 13, because the all full bench are not constitutional bench, but all the constitutional bench are full bench. That means to say 3 judges bench cannot interpret the constitution without the minimum number of 5 justices. So what was happened in Joseph Shine case? In Joseph Shine case, it was held that adultery was not a criminal offense, but it is a ground for divorce. For the purpose of interpretation, we should look into the section. First, what it says, a person having a sexual intercourse with a woman, knowing that she is wife of another, without the consent of her husband, that not amounts to rape, but amounts to adultery. In this section, we should look into the first line, a person having sexual intercourse with a woman. For the purpose of this section, for the interpretation of this section, the women category is classified into 5. The first one is spinster. The second one is wife. The third one is unmarried. The fourth one is divorcee. And the fifth one is widow. Among these 5 categories, this section is applicable only for wife, not for spinster, unmarried, widow, as well as divorcee. That means to say she is wife of another man. The object of section should be looked into. Whenever we want to interpret a section, the object of section should be looked into. The object of section 497 was that to maintain the sanctity of the marriage relationship, that to maintain the sanctity with respect to husband. So in this case, Joseph Shine case, what was happened that if a sexual intercourse between a man and a wife of another man is not amount, that too, one line is there, without the consent of her husband. So if the husband gave any consent, that's it, then this section was not applicable. So for that purpose, the then Chief Justice of India said that wife is not chattel of the husband. So based on this, the wife is, the respect to the wife should also be given. So for this purpose, wife is separated from all other categories like spinster, unmarried, widow, as well as divorcee. Then we will interpret the word how spinster differs from unmarried. For the interpretation of these 2 words, once again, we are going back to the object of the marriage. The object of the marriage, the first and foremost object is that legalizing the sexual intercourse. The second object is that procreation of children. So For that purpose, the spinster, until the age of menopause, she will be considered as spinster. When automatically the menopause starts, the women will be treated as unmarried because the object of procreation of children is not possible during the menopause. So this type of interpretation is very necessary to understand the literal meaning, what we call the letter and spirit of the section. So in this section, one more interesting thing is that this is the pure discrimination. This section is the pure discrimination of Article 14 and as well as 15. After Justice K.S. Puttaswamy case, the right to privacy is declared as fundamental right. The then Chief Justice of India, Chandrachud, Honorable Justice Chandrachud sir, was presiding over the bench, and the bench held that right to privacy is fundamental right. Based on this, we apply the right to privacy for adultery. Usually adultery happens between the four walls. So it is a pure violation of right to privacy. And what was another discrimination in this section is that women will not be treated as abettor in this section. Then what she would be? And what is the position of the wife in this case? So for offense, we all know that actus non facit trium nisi mensi tria. Mens rea should be there, actus rea should be there. And if we look into the parties to the offense, there should be minimum two parties. One is accused and another one is victim. In this case, 497 section IPC 1860, then the women or wife will be treated as victim. Even though she only solicited for adultery, she will not be considered as a abettor in this case. She will be treated as a victim. So for this purpose, the interpretation leads to unconstitutionality of the section 497 of Indian Penal Code 1860 then. This is a good example for interpretation. And one more case where the section 377 of Indian Penal Code 1860 in Navtej Singh Johar case held that it was unconstitutional. Based on the interpretation. Actually, this section 377 runs as follows. Whoever having corneal intercourse with men, women, and animal against the nature, then it will be a punishable offense according to section 377. So, first we should understand the heading of the chapter is that unnatural sexual offense. 377, Indian Penal Code 1860. First, we should know what is natural sex. Then we should understand what is unnatural sex. Once again, the natural sex is based on the object of marriage. That is penetration of the penis into the vagina for the reproduction of children. That is the main object of natural sex. Other than this, all sex, like oral sex, anal sex, will amount to unnatural sex. These type of sexual activities was considered before Navtej Singh Johar case unconstitutional and punishable offense. But after that, Navtej Singh Johar case, that is the sexual orientation, what we call LGBTIQA plus, that is L stands for lesbianism, G for gay, B for bisexual, T for transgender, Q for queer, A for asexual, and plus so on and so forth. It will goes on. So if the consensual sex between these sexual orientation community, it will not be considered as a offense after the Navtej Singh Johar case. In the year 2018, this case was also based on Justice K.S. Puttaswamy case, which is commonly called as Aadhar case. Because what we interpret here is that same, the right to privacy held fundamental right in Justice K.S. Puttaswamy case. So, same sex having sexual activities comes within the meaning of protective sex or whatever you call, and it is within the four walls. So, but this 377 section of Indian Penal Code was not held completely unconstitutional. But this section 377 held partially unconstitutional. Once again, because this section runs as follows. Any person having corneal intercourse with men and women and animal. So, the sex between same sex of men and women is allowed after the judgment of Navtej Singh Johar case. But the sexual activities with animal, what we call it as a bestiality, is offense today. Here we should look into the interpretation clause. Why the section 377 is not completely abolished? Because today also having sex with animal is offense. What we looked into here is that the main part is the consent. The consent is very much important. So if you want to have sex, anybody wants to have sex with animal, there is no opposite party to give consent. Animal can't able to give consent. Based on this, the section is held partially unconstitutional. That means to say consensual sex between the major persons, that is the age above 18, whether they belongs to LGBTIQA+, that is valid. But the sex with animal, that is bestiality, is invalid. That is why section 377 of Indian Penal Code was held unconstitutional. So, like this, the interpretation plays a vital role. That too in Constitution. In a Venkatesh case, Karnataka High Court said that the accident was occurred in NKWRTC, North Karnataka, because the driver was feeling the pain in the chest and he parked the bus looking into the 60 passengers, and he parked the bus in the left side and he dies away. When the son of the deceased filed a case against the insurance company denied to pay the insurance because it took defense there was no accident. Just the bus was parked left side of the road and driver dies away. So insurance company took defense like this. While an argument, the advocate for the deceased person argued that what is the exact meaning of accident? So, if you want to understand the meaning of accident, two principles will be looked into. One, that is accident is inevitable, that is beyond human control. There are two principles to measure the accident. First one, the accident inevitable and it is beyond human control. Then he applied the same principle to accident. Same principle of this accident to the heart attack. Heart attack is also inevitable and beyond human control. After applying these principles to the accident as well as to the heart attack, the court held that the insurance company liable to pay the compensation of rupees 24 lakhs to the deceased son. So mainly the interpretation plays a vital role in the cases dealing with that too in writ petition, constitutional matters. In another case, after Section 6 amended that women or daughters are also eligible to partition in the ancestral property. After this case, one Pallavi case, that is the before Honorable High Court of Karnataka, the father of the Pallavi was a government employee and he died during the service. She applied for compensatory job. According to Karnataka Civil Service rules, compensation job is only for son and not for daughter. But Karnataka High Court interpreted that. How in the partition the female or daughter is able to get partition equally footed with son. The same principle applied here also. In that case, Karnataka High Court held that daughter is also eligible for compensatory job if the deceased died during the service. Like this, the interpretation goes on in all the cases and plays a vital role. In another case, in recent case, couple of weeks back, Supreme Court, in POXO case, the question before the court was that whether the POXO Act is applicable for both genders. What was happened in this case was that a woman exploited a below 18-year child, sexually abused, and she took a defense that Section 3 of POXO Act applies only for men. That is, there is a particular word in Section 3 that is he. She took difference that perpetrators shall be male according to this section. Supreme Court held that this POXO Act is applicable for both male and female by saying that this POXO is gender neutrality, comes under gender neutrality. And she took another defense according to Section 3 of POXO Act. What was that is, penile penetration is mandatory. So Supreme Court interpreted that word, penile penetration, like penetration not only of penis, it also applicable to any digital penetration, oral penetration, manual penetration, like that. Interpretation was very much important to understand the letter and spirit of the section. After this case, Supreme Court said this POXO Act is gender neutrality. POXO Act comes under gender neutrality. Like this, the interpretation plays a vital role. Even though we studied in law, that is interpretation of statutes as a subject, this interpretation of constitution or constitutional interpretation is also very much important. What exactly interpretation means? We should read in between lines and we should understand the things and apply to our case. In interpretation, we should look into the exact grundnorm, what we call grundnorm in jurisprudence. Grundnorm of the section or the legislation shall be looked into. The interpretation of constitution is very much important. What we say, in one case, the Supreme Court held that we allow same-sex people to live together. Same-sex people to live together. And once again, the same couple challenged the marriage. But the Supreme Court held that. We allow living of same sex, but not marriage. Because the marriage is always between male and female. So same-sex marriage was not allowed in India today also. In one case, Supreme Court held that live-in relationship is also allowed. But the section 125, then section 125 of CRPC, they can't claim maintenance under section 125 because what was there in CRPC, now CRPC is replaced by BNSS. You all know that IPC replaced by BNS, Indian Evidence Act replaced by BS. That is different thing. I'm talking about the previous 125. So Supreme Court held that the maintenance cannot be allowed in live-in relationship. This is also based on interpretation of the word or letters, whatever may be used in section and act. We all know that in Shreya Shingal case, she challenged the validity of Article 19, Clause 1, Subclass A, which speaks about right to freedom of speech and expression. So Supreme Court held that Section 66A of Information Technology Act, which was enacted in the year 2000, after 15 years, in the 2015, Shreya Shingal, she was also a law student. She challenged the validity and constitutionality of the Section 66A of Information Technology Act 2000. The Supreme Court held that, yes, it is violation of Article 19, Clause 1, Subclass A, which speaks about right to freedom of speech and expression by interpreting the letter and spirit of the Section 66A. It violates Article 19, Clause 1, Subclass A. Long back in Vijay Emmanuel versus State of Kerala, Supreme Court interpreted that the silence is also amounts to respect. During the national anthem, Vijay Emmanuel was silent in the school, and the school authority was expelled him from the school, but because saying that he was not giving respect to the national anthem. So Supreme Court interpreted that word silence, standing and silence while national anthem. It is also a respect towards national anthem, and it is not a disrespect. So Supreme Court held that Vijay Emmanuel expulsion from the school is against the Constitution. And goes on like this. The Supreme Court, in so many cases, interpreted word by word, letter by letter of the Constitution. Even if we can take the preamble, what I was started with, The word socialist and secular was not, the secular word was not there in the constitution. Is what it was inserted in the year 1976, 42nd Amendment Act. In the year 1976. What was the rationality before adding that word secularism? Even though it speaks of caste, it also includes religion. The constitution is mainly based on the concept dharmo rakshati rakshitaha and laissez-faire concept, that is welfare of the society. Supreme Court interpreted that the religion and caste. So no person shall be treated unequal. And person should be equal person treated as equal, unequal should be treated as differently according to Article 14 of Indian Constitution. So after that, the unity and integrity in the preamble were added in the same amendment in the year 1976, 42nd Amendment, which is called as Mini Constitution of India. So unity and integrity, the word was added in the year 1976. And also, there was no fundamental duties when we enacted the Constitution. When Constitution came into force in the year 1950, January 26th, the fundamental duties were not there. After that, where there is right, there must be a duty. Based on this, that is what we say in torts, ubi jus, ibi remedium, where there is right, there must be duty. Supreme Court held that if there is a fundamental right in Part 3 of the Constitution, there also should be fundamental duties. Then we added fundamental duties under Part 4A of the Constitution. Because where there is right, there is remedy. Like that, where there is right, there should be duty. Like that, Supreme Court held. This is the interpretation of the Constitution is very much important. What I suggest for the students is that the interpretation clause must be looked into. What we say in a recent POCSO case, Article 14 is violated, Article 15, 16, like that. The Section 3 of the POCSO Act says that the interpretation of he includes she is based on Section 13, Clause 1 of General Clauses Act 1897. In General Clauses Act 1897, Section 13, subsection 1 says that if wherever, in whichever act or legislation we use the word he shall include she. That is, wherever we use masculine, and it is always followed by feminine. Based on this, in recent case, Supreme Court held that women also cover under the provision of POCSO Act. So, the interpretation, we all know that it is the function of judiciary. How to interpret the word is based on case, circumstance, and facts, and it may change according to situation. Because we all know that the judgment of Supreme Court binds on all other courts in India. The one question came before the Supreme Court that whether the judgment of Supreme Court binds Supreme Court or not. The answer is that Supreme Court judgment will not going to bind the Supreme Court, but it binds all other subordinate courts within the territory of India. Because if you allow the Supreme Court judgment binds itself, that means the law will become stagnant. So that the Supreme Court judgment will not bind the Supreme Court. In Shabarimala case, Supreme Court held that 4:1 ratio, women also can be entered into the Shabarimala temple. In 4:1 majority, 4 justices are male, but 1 justice, that is Honorable Justice Indu Malhotra, was female, and she was on the side of dissent. A question will arise, how can a female can deny the entry of women into the Shabarimala temple, even though she is female? Whenever a person becomes justice of High Court or Supreme Court, whatever it may be, whenever he enters judiciary, he or she will be genderless, and he or she will be treated as goddess of justice. That's why she wrote her dissent judgment saying that we are following this tradition that women cannot enter Shabarimala from the last so many years. So I want to follow the same tradition, she wrote in her judgment, because it affects the religious, affection. So after that case, in the year 1985, the famous case, Shaira Banu, this is before Shabarimala case, what I am talking is, in Shaira Banu case, Supreme Court held that Muslim women is also entitled for maintenance under section 125 of CRPC, because first she will be treated as Indian citizen, then she will be treated as Muslim. What was interpreted is, in this case here, was that CRPC, that is Criminal Procedure Code 1973, then it was applicable to whole India, including all religious people, whether Muslim, Christian, Parsi, Hindu, Sikh, whatever it may be. So after this case, the then Prime Minister of India, Rajiv Gandhi, enacted a new act that was called the Muslim Women Protection of Rights and Divorce Act 1986. After this act, all women, whether they are belonging to Muslim or not, Hindu or whatever it may be, the Muslim women will going to get maintenance under section 125 of CRPC. In recent case, Shaira Banu case, what I am talking was that about Shah Banu. Now, recently in Shaira Banu case, Supreme Court held that the triple talaq was banned because it is against the integrity of the women. Supreme Court interpreted it was against the integrity of the women. All women will be treated alike. So triple talaq under Mohammedan law was abolished in Shaira Banu case recently. So in so many cases, Supreme Court interpreted the words used in the act or the sentence used in the act with the letter and spirit of the act. The main concept of interpretation is that because even though the legislatures got the power to make law, but the executive will enforce the law, judiciary will interpret the law. So it is the duty of the judiciary, what we studied in Article 147, speaks about interpretation with regard to union judiciary as well as state judiciary. Interpretation, Supreme Court and High Court are called as court of records. And the law declared by Supreme Court binds in all other courts within the territory of India, and it will become the law of the nation. That is called judge-made law. We got around 4 sources of law, that is legislation, precedent, custom, and equity, justice, and good conscience. These laws made by the judiciary, that is called judge-made law, or precedent, or what you call stare decisis. So, while interpreting the words used in the act or used in the legislation, Supreme Court will observe with a view that there should not be any ambiguity in the understanding, and there should not be any ambiguity in the interpreting of the statute or act, whatever you call. So anyway, interpretation of constitution as well as or vis-a-vis with statute is very important topic to learn, not even for the students or law fraternity. It is for all the fraternity of the law. So by this, I want to conclude by interpretation of constitution vis-a-vis statute. Now the session is open for question and answers. Thank you one and all.
Thank you, sir. Haima, you can.
If anybody has any question, session is open for question and answer. Please raise your hand or type your question in chat box.
No, I've already raised my hands.
Yes,
Sir, it was a very good and a superb presentation.
Thank
It was
you.
very informative. Sir, I'm
Thank
very
you.
much curious to know about your qualification from your own words, sir.
Okay. First, I completed my diploma in pharmacy
Yeah.
in JSS Law College, JSS Pharmacy College, in the year 1991, almost 34 years back.
Okay.
After that, I completed my BSc in Biochemistry, Botany, Zoology. After that, I completed my LLB in JSS Law College, then LLM in JSS Law College, Medical Jurisprudence in JSS Law College, and Cyber Law in JSS Law College. Then I completed my MBA in Open University. Then I completed my MPhil in Criminology and Forensic Science in Maharajas College, Mysore. Then I cleared my set as a state topper in the year 2013, and once again, I want to check my knowledge in the criminology. I took the SLET exam also. I cleared by in the year 2014 as a district topper, and DLIT from University of South America, Montevideo. And I am now in final stage of my PhD in Karnataka State Law University.
We were really blessed to have such a highly qualified person giving sessions to our college students, sir. Thank you very much.
It's my pleasure. Thank you.
Any other questions?
Hello.
Participants, if you have any questions, either you can chat in the chat box or you can unmute yourself and please come forward. Haima, there is one question in the chat box. There's one question
So
in
there
the
is a
chat
one
box. Please
question.
read.
How
Yes,
do the
yes.
yes, sir. How do the doctrine of spirit of the constitution and letter of the law differ during the interpretation?
Yes. Very, very good question. See, I gave the example of POXO Act now. Section 3 of POXO Act. There is a word called he. He took defense by using this word. In that case, women exploited a minor child. She took shelter under this word. The spirit of the word he, the letter he, and the spirit is he includes she. Not according to general explanation, there is an act called General Clauses Act 1897. Under that, section 13, subsection 1 says, wherever we use masculine, automatically it attracts feminine also. That the word, that letter is he, the spirit of the letter he includes she. By this way, we should understand the letter and spirit. While argument also, we advocates use. I practiced before district court, high court, as well as the Supreme Court. During the argument, we use these words, letter and spirit. I want to bring the attention of this honorable court towards the letter and spirit of the section, my lord, what we used to tell before the court. Did you catch my point?
Now, this question is asked by Shalu R.
Yeah, okay.
She reacted, sir. Any other questions? Okay.
I have a question, Santosh here. See, when it comes to this nominees, the person has died, naming a person as nominee or he has legal heirs concerned.
Yeah.
Now, when the person dies, in the case of a bank, he's got a fixed deposit.
Okay.
Now, who should it go to actually? Now, what is the kind of interpretation here we may expect if the nominees are there while nominees represented in that bank form? One. Two is, if there is a case where legal heirs are also there, who could claim?
Legal heirs, huh?
Yeah, legal heirs are also there for the person who died.
Actually, in recent case, the Supreme Court interpreted the nominee. The nominee whose name is there, whatever in the bank or whatever it may be, if the husband dies, for example, whoever may be the nominee, the amount will goes to the wife, spouse. Are you understood?
Yes, sir.
Have you got the point?
Yes, sir. I could interpret that.
Oh.
That's about. Thank you so much, sir.
Okay.
Any other
Sir,
question?
good evening, sir. Rajiv here, sir. Just want to ask a
Rajiv.
question.
Ah.
Yes, sir, Rajiv here.
Yeah, Rajiv.
Sir, actually, I think most of us know that Bill Gates' agenda of 2030, wherein he wants to. Are you able to hear me, sir?
Yeah. It's audible.
Yeah, okay. According to him, Agenda 2030, he wants to get this controlled fertility and reproduction, radically assisted suicide and abortion laws. He wants to even destroy the motherhood and fatherhood, destruction of gender. These were going on in the background, sir. And it's been happening since past 15 years very silently.
Okay.
His kind of intention is to control world population by 50%. So don't we feel that these are all part of the agenda, what is being done through the elites of the world?
But then,
elite people like him, Bill Gates, the BlackRock Foundations.
lack of foundations with regard to?
BlackRock Foundation, a shop.
With regard to?
So, no, don't we feel that these are the agenda of these people? They are trying to create the new laws, all this kind of destruction of humanity in the planet. This is what they are trying to do.
If they are distracted or if they are affected, they can approach the court via media.
No, they themselves are creating this havoc, sir. So how to stop this? That was my question.
Please repeat your question. I didn't got it.
No, actually, Bill Gates and
Short.
Okay. So many people are planning to do this like abortion law,
Yes.
destruction of motherhood and fatherhood, destruction of gender. So that is when actually living couples, those things are increasing. So don't we feel that there has been already staged in the background?
Yes, of course. What you are telling is right. It happens frequently in live-in relationships, no?
Okay.
Actually, the live-in Supreme Court allowed. There is no dispute in live-in relationship. But what I told in previously, that is, you can't claim maintenance in live-in relationship. Because maintenance is only for, according to CRPC, what I am talking, now it is BNSS, only husband, only wife, children and parent will got maintenance. Like that. Not the live-in relationship. Huh?
Okay, sir.
Okay. Yes, any questions? Hello?
Haima, maybe you can take over now.
Emma, I think questions is also closed. So you can
Haima, you are mute.
Yes.
Please unmute yourself.
Yeah, ma'am. Okay, then we'll wind up the session.
Okay.
It's my privilege to deliver the vote of thanks for today's insightful webinar on the topic Interpretation of the Constitution. First and foremost, my heartfelt gratitude to our resource person, Professor Yogesh J, Principal of PES Law College, Mandya. Sir, your presentation was very good. I got very inspired.
Thank you.
For his enlightening and thoughtful provoking sessions, sir, your deep knowledge, clarity of explanation, and engaging delivery truly helped us understand the essence of constitutional interpretation. We are grateful for the time and the effort you took to guide us today. My sincere thanks to our management team, principal for the constant encouragement and support. A warm appreciation to our teaching and non-teaching staff for the cooperation throughout the event. A special thank to our backend team for the smooth technical coordination. A final big thank you to all the participants for your active involvement and enthusiasm, which made this session even more meaningful. Thank you. Thank you everyone once again.
Thank you.
Thank you, sir. Thank you, everyone, for joining the session. We'll meet tomorrow, same time.
Okay. So thank you very much, sir, for your exhaustive knowledge over here. And you have given a good knowledge for the students, because it is a decision of the court how you can go ahead and interpret it and what are the differences, everything we are giving the knowledge for the students. Thank you very much, sir, for your enlightened speech and webinar over here. And I'm also thankful for the Mohan Kumar, sir, because he has given this type of an opportunity, resource person for us to give the webinar in this occasion. And I'm thankful for every back end also. I thank you very much, sir.
Thank you.
Shall we close the session now?
We will wind up the session. Thank you, everyone.
Yes.
Yes, sir. Thank you.
Thank you. Bye.
Thank you.